Is, hmm? Okay. I think so.
The Subcommittee on Regulatory Reform, Commercial and Antitrust Law hearing will come to order. Without objection, the chair is authorized to declare recesses of the committee at any time. Our subcommittee hearing today is being held to examine old and outdated federal regulations that are a barrier to the new job creation that we so badly need in our country. Let me commend Congressman Jason Smith of Missouri for the work he has been doing on this issue and for legislation he will soon be introducing, the Searching for and Cutting Regulations that are unnecessarily Burdensome Act of 2014, for short, the Scrub Act. This subcommittee has heard testimony which has made a compelling case that federal agencies do not properly account for input from small businesses and too often ignore the cost associated with new regulations. Today, we consider an even larger problem. What happens to all those regulations passed long ago that no longer serve a useful purpose or no longer provide a benefit? Ronald Reagan once said, "Nothing lasts longer than a temporary federal program." He could have added federal regulations to that. Nothing lasts longer than federal regulations. No one who has studied the regulatory structure in this country would dispute that there are a lot of outdated federal regulations on the book that no longer pass a cost-benefit test and that in some cases no longer make sense. Employers spend time, money, and resources complying with antiquated regulations that could be better spent on hiring more workers or reinvesting in their enterprises. The total federal regulatory burden has reached 1.75 to 1.8 trillion by some estimates. If we remove just part of this burden, we'd see immediate economic growth. The Scrub Act establishes a systematic process for doing this. It would set up a BRAC-style commission to identify regulations that have been rendered obsolete by technology and the markets, that have achieved their goals or that are duplicate or conflict with other federal regulations. The Commission's recommendations to eliminate those unnecessary regulations would have to be implemented by agencies unless disapproved by a joint resolution of Congress. There's a role for federal regulation that provides reasonable and clear rules of the road for businesses that provide benefits to the public that are greater than the cost. But we should acknowledge the unneeded burden that redundant and obsolete regulations place on job creation and our economy. Accordingly, I look forward to today's testimony. At this time, I'll recognize our new ranking member, Hank Johnson of Georgia, for his opening statement, and would like to say welcome as a new subcommittee chair to your position. And so you're recognized for your opening statement, Ms. Johnson.
Thank you, Mr. Chairman. I'm a little hesitant today because I have been informed that earlier this morning a gentleman was sitting in this chair and the gentleman was operating this microphone, and in doing so, he sustained a shock. And so I am deeply concerned that I may not survive this hearing.
Well, we've learned since then that he rests in peace.
Well, I'm hopeful that that you all are praying for my salvation. And but I'm pleased to now serve as the ranking member on the subcommittee on regulatory reform, commercial and antitrust law. As the former chairman of the antitrust subcommittee, I know that it has a particularly exciting range of issues, many of which should provide a pathway to work cooperatively across the aisle. That is why I'm particularly disappointed with the process and substance of today's hearing, which is my first as ranking member. Regarding process, although today's hearing is intended to be a legislative hearing, we did not receive a copy of the draft legislation until Friday afternoon and did not receive a final version of the bill until yesterday evening. This is obviously problematic. It not only affects our ability to adequately prepare for the hearing, but also the ability of our witnesses to carefully analyze the legislation and draft their testimony under severe time constraints. As to substance, it had been my hope that the subject matter of this hearing would have better lent itself to a more collaborative effort. I think all would agree that retrospective review is a good idea. There's no doubt that out-of-date, redundant, and conflicting rules should be eliminated. In fact, President Obama, in recognition of the value of retrospective review, issued a series of executive orders requiring agencies to effectuate review plans, a process that is now in effect. This process is in addition to the self-initiated reviews that many agencies conduct, as well as the reviews conducted pursuant to the Regulatory Flexibility Act. Unfortunately, the so-called Scrub Act, which is the subject of today's hearing, appears to be a one-way ratchet with the sole aim of prioritizing costs over benefits. The measure fails to give agencies the necessary resources and guidance so that they will do an even better job of conducting retrospective review. Even more problematic is the fact that the Scrub Act may very well be plainly unconstitutional. As Professor Levin explains in his prepared testimony, the Commission, as established by this legislation, is given comprehensive authority to take actions that would have the force of law, even though its members are not presidential appointees subject to Senate confirmation. I do not believe Professor Levin has reached this conclusion without careful reflection, and I encourage him to focus upon that issue in his oral testimony. Compounding the problem is the fact that the bill uses undefined terms that are inherently subjective in nature, such as, quote, excessive compliance cost, end quote, and excessively burdensome, end quote. Clearly, excessive can be a matter of opinion depending on which perspective one views the issue, such as regulations that save lives but impose certain compliance costs. As a result of these and other serious flaws with this legislation, it's clear that the Scrub Act is yet another short-sighted anti-regulatory measure that has no hope of becoming law. But I do have hope that I will survive this hearing, and I hope that during this time Chairman Bacchus and I are working together on this committee, that we will be able to find common ground on process and substance. As we begin this new session of Congress, I very much look forward to working with you, Mr. Chairman, and I yield back.
Thank you. Ms. Johnson, we did have a very good meeting earlier today, and I think we've mutually pledged to try to work cooperatively together and try to find consensus on issues, and I appreciate your spirit of cooperation that you've shown in the past. And I will say to you that this bill, in its preparation, did come late, and I think there was some, obviously, some limited time that you had to review it, and I concede that to you. And in the future, we'll work together to see that that's not the norm, but that's the exception. And with that, yes.
Would the gentleman
Yes.
yield? Yeah, I might add, Mr. Chairman, that I have such great respect and admiration for you. You've been a vocal supporter of civil rights, being an initial co-sponsor of the Voting Rights Amendments Act, and this kind of conduct that you have exemplified throughout your years in Congress is a hallmark of civility. And so I have no doubt that whatever happened this past week is something that happened, but you know, we're going to proceed on from here. And so I look forward to serving with you, and I think everything's going to be okay if I survive this hearing.
Well, thank you. We'll try, make every effort to get you through this hearing, and I appreciate your words. With that, I'd like to recognize the sponsor of this legislation, Mr. Jason Smith of Missouri, for opening statement.
Mr. Chairman, thank you for holding this hearing. Much appreciated. As a former chairman of the Joint Committee on Administrative Rules back in the Missouri House, which I served just over 8 months ago, I have some experience working to reduce the regulatory burden facing families, small business owners, and farmers. In 2012, while serving in the Missouri House of Representatives, I worked to pass House Bill 1135, which requires that all state rules and regulations be reviewed every 5 years. Like the bill we are discussing today, House Bill 1135 required that rules be examined under various criteria to determine if, among other things, they were effective, obsolete, or duplicated. The federal government could learn a thing or two from what we've accomplished in the state of Missouri. It was Missouri's over 6,000 state regulations that led me to believe that reform was necessary. In the Code of Federal Regulations, there are over 174,000 pages of rules and regulations. During my short time in Congress, I've been amazed by the broad federal authority agencies have to write numerous new regulations. Worse yet, Congress and the American public have very little oversight and authority over agencies' rulemaking process. The searching for and cutting regulations that are unnecessarily burdensome Act of 2014, or Scrub Act, creates a bipartisan commission to examine federal rules and regulations that merit repeal and amendment to reduce unnecessary cost burdens for American citizens. In addition, it requires an automatic review on all new rules after 10 years and creates a cut-go procedure whereby agencies need to repeal old regulations before they can issue new ones, absent congressional consent. I look forward to hearing from the witnesses and other members about ways to really tackle regulation reform and invite input on a way to move forward. Thank you, Mr. Chairman, for this opportunity today to discuss this legislation.
Thank you, Mr. Smith. I would now like to recognize the full committee ranking member, Mr. John Conyers of Michigan, for his opening statement, and also warn you that we are getting shocks from some of these mics. So,
Well, thank you very much, Chairman Bacchus. I am here to participate with a question. Why don't we have a bill instead of a discussion draft with these distinguished witnesses that are here?
That is a good question, a valid question. It's my understanding that in introducing the bill, there were some, no. As my able counsel advised me, we had already sent witnesses notice when we realized that we weren't going to be assigned a bill number. But actually, the draft before you is the bill in its final form. It doesn't have a number. And I'm not sure that I can give you an explanation of that. So I'm not going to give you an incorrect. But I understand, as I told Mr. Johnson, I mean, in response to his statement, that is an anomaly, and we'll try not to repeat that in the future.
Thank you, Mr. Chairman. Can you, Mr. Bacchus, indicate to me when the bill will be dropped and we will be able to compare the discussion draft with the actual legislation proposed?
Yes, my understanding that this is the bill in the final form. Other than, but there's Mr. Smith could.
Oh, I'll yield to Mr. Smith.
Can you hear me? Yeah. You know, this appears to be the bill in the final form. One of the purposes of a draft legislation is I want some true bipartisan regulation reform. And this is a way to start. And if you all have suggestions on how to move this forward to actually do some substantial reform, this is the way that we can make the changes.
Well, when will the bill be introduced?
Well, right now, I would say as soon as possible, but I mean, we've been working on this for some time.
I would say this: by the time we reconvene after today, our next legislative session, which is about 10 or 12 days away, assuming that we address our debt ceiling today, which I'm assuming we will, when we return, we should have the bill in final form.
Thank you very much. I'd like to ask unanimous consent to introduce two of President Obama's, well, actually three executive orders, but I have three executive orders outlining steps that federal agencies must take to formulate plans for retrospective review of their regulations on an ongoing basis.
Without objection.
And in compliance with these directives, executive agencies and various independent regulatory agencies have submitted retrospective review plans. Altogether, these plans have identified numerous ways to reduce redundancy and inconsistency among existing regulations. As the Coalition for Sensible Safeguards notes, the Commission would itself be redundant and duplicative in light of the President's executive orders. It should be noted that this process comes in addition to the ongoing retrospective review efforts that agencies have been undertaking even before the issuance of these executive orders. As the Government Accountability Office reported in 2007, agencies routinely conduct these, often at their own initiative. And to that end, the GAO has made several recommendations to improve that process, which would have been a good starting place for any analysis. Unfortunately, we have a one-sided, unbalanced approach that has been alluded to by the ranking member from Georgia on this subcommittee, Hank Johnson. As a threshold matter, the commission is plainly unconstitutional, as will be explained very shortly, because it empowers the commission to take actions that would have the force of law in violation of the Constitution's appointment clause. And I'll let him handle that from there. Virtually all of the bill's objectives have this one-way approach. It's a measure designed to result in the repeal or amendment of a rule only to eliminate or reduce costs. And in contrast, the bill doesn't do anything, very little or nothing, to promote actions that would enhance the benefits of rules. Another point that I might want to make is that the commission members, other than the chair, would not be required to have any expertise in either administrative law matters or the subject matter of the rules that they consider. Notwithstanding that fact, the commission would be empowered to second-guess Congress with respect to the need for certain rules, as well as the agencies with respect to the science and analysis warranting such rule. And the most grievous part of the bill is the so-called cut-go offsetting provisions, which come into play even if Congress enacted a joint resolution to disprove the Commission's report. Now, after all of that, I'm amazed that we're here today. I can sympathize with the chairman of this subcommittee, as does the ranking member, because he is held in high esteem by his colleagues on both sides of the aisle. But this legislation, this provisional draft is hardly a way for us to start an important hearing like this. And I submit the rest of my statement and yield back the balance of my time.
I thank you, Mr. Chair, Mr. Ranking Member. I'll still call Mr. Chairman when I served under you. And we have a very distinguished panel today, and I'd like to introduce the witnesses. Dr. Patrick McLaughlin is a senior research fellow at the Marcatus Center at George Mason University. His research focuses on regulations and the regulatory process with additional interest in environmental economics, international trade, industrial organization, and transportation economics. His research and opinions are regularly published. Prior to joining Marcatus, Dr. McLaughlin served as senior economist at the Federal Railroad Administration in the United States Department of Transportation. And as a former railroad attorney and in Congress, you know, railroads is sort of probably my favorite subject. I have followed your work and your work there, and appreciate your work in the field of railroad transportation. Very few people understand the railroads, understand the tremendous economic benefit they bring They really keep our economy rolling. And they are one of the least understood modes of transportation. I still get questions all the time about people saying, do the passenger trains and the freight trains run on the same line? Normally the answer is yes, but sometimes it's no. But Dr. McLaughlin has published in the fields of law and economics, public choice, environmental economics, and international trade. He holds a PhD in economics from Clemson University. And so thank you. Mr. Sam Batkins is Director of Regulatory Policy at the American Action Forum. Mr. Batkins' research focuses on the rulemaking efforts of administrative agencies and related efforts of Congress. His work has appeared in the Wall Street Journal, the New York Times, the Hill, National Review Online, Reuters, and the the Washington Post, among other publications. In fact, you just recently published a study that's drawn quite a lot of publicity, I think, and has some rather important findings. Prior to joining the forum, Mr. Batkins worked at the U.S. Chamber of Commerce Institute on Legal Reform and the National Taxpayers Union. At the U.S. Chamber, he focused on lawsuit abuse, tort reform, and federal regulation. At the National Taxpayers Union, he focused on state and federal spending. Mr. Batkins received his BA in Political Science summa cum laude from Sewanee, the University of the South. He received his JD from Catholic University of America, Columbus School of Law. We welcome you before our committee. Mr. Ronald Levin, who's testified before our committee on several occasions, is William R. Orthwein, is it? A distinguished professor of law at Washington University in St. Louis. He is co-author of a casebook, State and Federal Administrative Law. Professor Levin has chaired the section of Administrative Law and Regulatory Practice of the American Bar Association, a group to which he is still an active member. He served as the ABA's advisor to the drafting committee to revise the Model State Administrative Procedure Act. Professor Levin also serves as a public member of the Administrative Conference of the United States and the chair of its Judicial Review Committee. Professor Levin clerked for the Honorable John Godbolt of the U.S. Court of Appeals for the Fifth Circuit and practiced with the Washington, D.C. firm of Sutherland, Asbell, and Brennan. He received his BA from Yale and his JD from the University of Chicago. Quite a distinguished academic institution. And that was with Fifth Circuit in New Orleans?
It is now, but at the time...
It was in Atlanta? Or what?
Well, so the situation is that the Fifth Circuit was broken into two.
Yeah,
So at
11th and the 5th.
At the time of my clerkship, Judge Godbolt was on the Fifth Circuit. Then after the break, he was on the 11th Circuit, the only judge who's ever been chief judge of two circuits.
Okay, so he is in Atlanta now, or he, well, you would...
At that time, his chambers were in Montgomery. The base of the court was New Orleans.
All right. Thank you. I knew, obviously, he's a very distinguished jurist. We will now proceed under the 5-minute rule with questions. I'm going to recognize Mr. Smith for 5 minutes, if you're ready to proceed. I should have given you some warning.
Are they going to testify first, Mr. Chair?
Oh, that's what Barney Frank used to do all the time, and now I'm doing it. It must catch. I can't believe I did that. Yes, we absolutely, Mr. McLaughlin, if you can begin your testimony. I'll have to quit following this script.
Chairman Backus, Ranking Member Johnson, and members of the committee, thank you for inviting me. As an economist and senior research fellow at the Mercatus Center at George Mason University, my primary research focuses on regulatory accumulation and the regulatory process. So it is my pleasure to testify on today's topic. The accumulated stock of regulations almost certainly contains a multitude of unnecessary burdens. As the title of the discussed legislation implies, the current regulatory system makes it difficult to identify and eliminate such unnecessary burdens. Our goal here today should be to ascertain whether the Scrub Act would succeed where previous efforts have failed. To that end, first I will discuss why regulatory accumulation is a problem, which is primarily that it creates substantial drag on economic growth. Second, I will discuss the search for obsolete, unnecessary, duplicative, or otherwise non-functional regulations, covering both why similar searches in the past have failed and what could be done differently to increase the odds of success. In my estimation, an independent commission, as opposed to regulatory agencies, is required to successfully identify non-functional rules. Third, I will address the difficulties of eliminating non-functional rules once identified. Here I point to the wisdom of the crafters of the BRAC process. Finally, I will cover specific recommendations for effectively reducing the problem of regulatory accumulation, recommendations that are directly relevant to the Scrub Act. By design, regulations restrict choices. These restrictions have accumulated for decades, exceeding 1 million by the year 2010. This accretion of restrictions is what I refer to as regulatory accumulation. Regulatory accumulation inhibits innovation. And I'm not just talking about business ideas that would create new products and jobs. Would-be entrepreneurs are sometimes prohibited from pursuing ideas that could improve the environment and consumers' quality of life. My written testimony gives a couple real-world examples of how regulations can actually deter environmental stewardship and prevent companies from implementing potentially life-saving technologies, which I'd be happy to discuss. Through lost innovation and entrepreneurship, regulatory accumulation negatively affects economic growth. An academic study found that between 1949 and 2005, the accumulation of federal regulations has slowed economic growth by an average of 2% per year. Over a 57-year period, that adds up to about $277,000 in lost annual income per household. So how can we fix the regulatory accumulation problem? The solution boils down to two elements. First, we must identify non-functional rules. Second, once identified, non-functional rules should be eliminated or modified. In my written testimony, I've identified 11 elements that my research with my colleague Richard Williams identifies as characteristics of successful regulatory reform. I want to highlight just 3. First, the process should entail independent assessment of regulations. Independence is crucial. Our study documents attempts by every administration since Reagan's to address regulatory accumulation. Those attempts share at least 2 characteristics. Each of them relied at least partially on agencies to assess their own stocks of regulations, and each of them failed in substantively changing the stock of regulations or the ongoing accumulative process. If the reasons for these efforts' limited success is their reliance on agency self-assessment, then an independent commission could be a better alternative. Second, the process should use a standard method of assessment, and that method should include a focus on whether and how rules lead to the outcomes desired. There is a difference between outcomes and outputs. A rule may lead to an increase in an output, such as increased safety inspections, but that does not guarantee that there has been an increase in the outcome, safety. The assessment of rules should focus on outcomes. Third, congressional action, such as a joint resolution of disapproval, should be required in order to stop the Commission's recommendations. I previously mentioned the wisdom of the crafters of the BRAC process. Legislation addressing regulatory accumulation must overcome similar obstacles as the BRAC process did. One of those is the possibility of congressional inaction. In order to stop the recommendations put forth by the BRAC Commission, the BRAC process required Congress to pass a joint resolution of disapproval. In other words, even if Congress did nothing, the default was implementation of the recommendations. These are 3 of the 11 elements that our research has identified as essential to success. Regulatory accumulation in the U.S., with its adverse impact on economic growth, is now a widely recognized problem. The problem has not been meaningfully addressed despite the efforts of several administrations. My written testimony covers other essential elements that my research indicates are necessary, and I've highlighted just 3 now. I'd be happy to answer any questions after this is finished. Thank you.
Thank you. Your opening statement was exactly 5 minutes.
I had a little bit more, so
Yeah, I don't think I've ever had a 5-minute opening statement. It was right to the second. So, Mr. Batkins, and you don't have to be right to the
I
second.
probably won't replicate that.
No, I'm not expecting to see that again this year.
Thank you, Mr. Chairman, Ranking Member Johnson, and members of the subcommittee. Thank you for the opportunity to testify today and examine regulatory reform opportunities. I'd like to start by highlighting the successes and struggles of President Obama's current attempt at regulatory reform and the potential benefits of codifying retrospective review. First, when President Obama continued the strong tradition of ensuring that regulatory costs justify benefits, he called for a periodic review of existing significant regulations. President Obama and then OIRA Administrator Cass Sunstein made a very public push to highlight some of the redundant and outmoded rules in our regulatory system, including the fabled spilled milk regulation. The administration has released plans with hundreds of possible retrospective reviews, but upon closer scrutiny, it's clear that many of these measures aren't regulatory lookbacks, and they don't streamline, expand, or repeal existing regulations. For example, the Department of Energy lists 19 rulemakings in its latest retrospective report. However, 6 of these are new energy efficiency standards that do not appear to revisit existing rules, but instead impose significant new costs. Likewise, Health and Human Services included at least 9 Affordable Care Act regulations in its latest report. These measures didn't look back at existing regulations or attempt to repeal certain regulatory provisions. Instead, they implemented the recent healthcare law. There have been successes in regulatory reform. The Department of Transportation plans to save the trucking industry $1.7 billion annually and cut the agency's paperwork budget by 15%. Likewise, HHS finalized a rule to reduce procedural hurdles for hospitals and healthcare providers, saving approximately $900 million annually. However, if we examine all retrospective reports and compare new rules that impose costs and compliance time to rules that actually look back to streamline or eliminate costs, the ratio is 3.7 to 1 in favor of higher costs. For paperwork, the ratio is 6.7 to 1. In other words, retrospective reports contain more new rules with higher costs than regulatory lookbacks with lower costs. Regulatory reform through executive order alone has not produced the desired results. During the past 10 years, the nation's cumulative paperwork burden has increased 28%, or 2.2 billion hours. And the equivalent amount of time it would take 1.1 million new employees working 2,000 hours a year to complete these new requirements. Codifying retrospective review would cement more than 30 years of informal review into law. I believe legislation that addresses the nation's cumulative regulatory burden would have a variety of benefits. The Government Accountability Office, as we've noted here, has highlighted duplication in its annual report for the past few years. GAO found 17 areas of duplication, including veterans employment and renewable energy. We replicated GAO's methodology for paperwork requirements and found 990 duplicative forms and more than 642 million paperwork burden hours. The regulatory cut-go provision in the proposed legislation would address this duplication by allowing agencies to choose from a range of past rules eligible for reform. To date, the U.S. has never had a formal system to address regulatory duplication, but if the Commission is successful, it could identify hundreds of past rules in need of reform. To some extent, the U.S. is behind the curve on regulatory reform. The United Kingdom has a system to remove 2 regulations for every new rule. Closer to home, Indiana has codified retrospective review for regulations 3 years after implementation. The proposed legislation actually provides agencies with some deal of flexibility compared to the British 1 in, 2 out system. Perhaps most importantly, the proposed bill would extend some level of OIRA review to independent agencies, the same regulatory bodies that govern our telecommunications and financial system. During the past 2 years, financial regulators have produced more than 113 regulations with quantifiable burdens, with little executive oversight. As the Administrative Conference of the United States has noted, it is past time for heightened regulatory scrutiny of independent agencies. In conclusion, I'd like to emphasize that retrospective review dates back to the Carter administration and is by no means a radical step. It's simply implementing best practices. Thank you for your time, and I look forward to answering questions.
Thank you. Professor Levin, recognized.
Yes, Mr. Chairman, I apologize for arriving a few moments late. I appreciate
You actually arrived fine.
Okay,
So
that's good. Well, Chairman Backus, Ranking Member Johnson, and members of the subcommittee, thank you for inviting me to testify on retrospective review today. I did testify on general principles in this area in 2012 before you. It's a privilege to return to the subject in the context of a specific bill. As we all know, the regulatory system already has a number of methods of inducing agencies to do more look-back review, and they include some statutes, presidential initiatives like the one President Obama pursued, congressional oversight, and the ability of anyone to file a petition for revision or repeal of a regulation and get an answer from the agency and potentially get judicial review. The question is whether we need to supplement these systems with a new mechanism. I think the case for doing that has been overstated. We should not equate the growth of regulations with the growth of unnecessary regulations. Many of them are directly contemplated by legislation and confer enormous benefits on society, such as safe skies, clean air, safe workplaces, and a sound banking system. It's often the absence of regulations that causes harm to our economy and society. But we can't agree that some rules are obsolete and ineffective or cause unwanted side effects, and I would not rule out the possibility that some new structure could be helpful. But the one contemplated by the Scrub Act is not it, in my judgment. In the first place, the commission that it would establish does not comply with the Appointments Clause of the Constitution. Most of its members would be appointed by House and Senate leaders of the majority and minority parties. A group like that can recommend, but it cannot itself exercise significant authority under the laws of the United States. The Supreme Court established this in Buckley against Vallejo in 1976. I know Representative Johnson asked me to elaborate, but really the law is clear and simple, and unfortunately this bill is on the wrong side of it. But let's assume that you fix that defect and look at the bill's policy implications. The Commission would still not be a credible authority because most of its members would not need to be experts in anything, and they could not possibly be experts in all the areas that they would have power to affect. And that power would be breathtaking. They could order the elimination or amendment of any rule of any agency that they consider unnecessarily burdensome. And they could use any methodology they want. Even soothsayers or astrological charts would do under the bill, and nobody could prevent their decisions from going into effect. Not the courts, presumably, not the agency. OIRA and the White House would have no review. And even if Congress passes a disapproval resolution with the House, the Senate, agreeing, the President signing, the Commission's decisions would still be merely postponed, not canceled. And if all that isn't far-fetched enough, a minority of the Commission, outvoted, could wield these same powers. In Justice Cardozo's phrase, this is delegation run riot. Then the bill provides for a cut-go process in which an agency cannot adopt a new rule without offsetting its cost with a rule from the Commission's list. The biggest problem with that is that the Commission's list itself would not be reliable. But also, this process would complicate the process of rulemaking, no matter how important or urgent the rule may be. And finally, the bill provides that every new rule, no matter how trivial, would have to be accompanied by a plan to re-examine it a decade hence. That's way overbroad for most rules. And even for important ones, it's premature to make a plan in 2014 for how you're going to re-examine it in 2024 when you can't foresee what the situation a decade from now would be. So I really think that the subcommittee needs to take a pause in this area. The best thing it could do would be to wait for the forthcoming recommendations of the Administrative Conference, which is now launching a study of retrospective review to be finished by the end of the year, see what proposals they make. But if the subcommittee does decide to go forward with this bill, the bill will need a thorough and fundamental scrubbing. That concludes my statement, and I'll be happy to take your questions.
Thank you, Professor. I'll recognize myself for 5 minutes for questions. The ranking member talked about the administration efforts to identify regulations that could be either eliminated or amended. how does the Scrub Act, I'll ask each of you, how does the Scrub Act compare to other executive branch and legislative proposals that have been brought forth in the past? And what, I'll just start with you, Dr. McLaughlin.
I think the most fundamental difference is putting the responsibility for retrospective review in the hands of an independent commission as opposed to leaving it in the hands of the agencies who created the rules in the first place. And it's my opinion that that will improve the quality of assessment. It's sort of, to make a simplistic analogy here, I'm a professor as well as a researcher, and if I let my students grade their own tests, I would expect, on average, their scores to be a lot higher than if an independent arbiter were to grade them and give an objective analysis.
Mr. Batkins?
I'd agree with Dr. McLaughlin that there is, I think, a need for an independent look at retrospective review. And if you just look at all the data we've compiled under Executive Order 13563, there are a few provisions that streamline, modify, reduce hours and costs, but on net, a majority of the provisions are actually new regulations that they're including in these retrospective reports. It's tough to tell the difference between the regular unified agenda of federal regulations and a lot of these retrospective reports. Several agencies that we reviewed didn't have a single measure that we found to actually look back at existing regulations. So I'd agree that an outside voice is probably welcome.
Could you give me some specifics on those agencies that you're talking about?
Well, sure. I mentioned Health and Human Services. We counted, judging from the RENs, from their report, there were at least 9 Affordable Care Act regulations that they plan to implement. And for example, the Department of Energy had several new efficiency standards for transformers, for metal halide lamp fixtures, and a lot of agencies will include basically a boilerplate that this rule is designed to minimize burdens consistent with Executive Order 13563. And that may be fine, but you could have used the same minimize burdens, maximize net benefits under Executive Order 12866 or Executive Order 12044. So it wasn't necessarily a regulatory look back as it was implementing a new rule and putting it in your retrospective report.
Professor Levin?
Oh, I agree with Mr. McLaughlin that the biggest difference is that the Scrub Act would put an independent body into control rather than the agency, but I think that's a vice and not a virtue. I think the better comparison would be if he asked me to grade his exams in his course, when he's the one who runs the course, organizes it, and I'm a complete outsider. The problem is that the agency has always been rightly considered to be the best entity to evaluate the rules. They have the expertise. That's why Congress created it in the first place, to bring specialized experience to bear. They are the ones who understand the overall program and all the interconnections among the different parts of the program. And they're the ones who are politically accountable in the way that a commission would not be. So we agree on the difference, but we don't agree as to its merit.
Are agencies really politically accountable for their actions?
For sure. Executive agencies are accountable to the president. All agencies are accountable to Congress. They're accountable at both the initiation stage. Congress can change their laws. They have oversight hearings, as you well know. And they're part of an administration, usually, that is very cognizant of public opinion.
Well, you know, out of all the regulations that have been passed over the years, there's been one that's been repealed by Congress. So, yeah, and of course, you could look at that 2 different ways. One is that they've all been appropriate, but another that Congress simply has lacked it. Because I think it's fair to say that there were probably, in a universe of tens of thousands of regulations, there had to be hundreds, if not thousands, that were probably not well thought out. But,
for sure, but it's not just the Congressional Review Act to take into account. Authorizing legislation will sometimes have that effect, And informal contacts through the oversight process will often have that effect because agencies are dependent on Congress in so many ways.
Okay, I think my time is expired. So this time I recognize the ranking subcommittee member.
Thank you. Dr. McLaughlin, the Mercatus Center is a 501c3 nonprofit that does not receive support from George Mason University or any federal or state or local government, and only receives funding through donations from companies like the Koch brothers. Is that correct?
Our organization is funded by private donations. However, we have a strict firewall between fundraising and research.
Well, no.
I'm not familiar with the details of the fundraising.
But companies like Koch Industries are companies that would be contributors or funders of your efforts. Is that right?
Again, I'm not familiar with the details of our fundraising.
Are you aware of the fact that the Mercatus Center moved to George Mason University after George Mason University accepted $30 million from the Koch brothers?
That was prior to my time working at the Mercatus Center, so I didn't experience that if that's what occurred. Again, what matters to me at least is that we have this firewall of separation between all the fundraising and the research. My research is my own, it's not influenced or controlled by any donors.
All right, thank you, sir. And Mr. Batkins, you ever heard of the American Action Network?
Pardon me? The American Action Forum, no, that's a separate organization. The American Action Forum is a 501c3. The network is a separate organization with a separate board.
It's a 501c4.
Correct.
And it's your sister organization, correct?
They have a separate board and a separate president, and
but your sister corporations, basically.
I rarely, if ever, have any interaction with the network, and I focus purely on the policy analysis and regulatory policy, and I have never engaged in any political advocacy, the kind that the network does engage in.
Mm-hmm. The network and the forum are housed in the same offices, which are basically sharing office space with Crossroads GPS and American Crossroads. Is that correct?
That is not correct. American Crossroads, I believe, is off of New York Avenue, and we are a few blocks away on Pennsylvania Avenue.
What about Crossroads?
No, it's just the American Action Forum, the American Action Network.
So you do not share office space with Crossroads GPS?
We do not.
Have you ever?
During the formation of our organization in 2010, for a few months we did.
And Crossroads GPS / American Crossroads is, of course, tied to Karl Rove.
That's my understanding, yes.
Mm-hmm. Is the forum or the network still tied to Karl Rove?
No, that's a completely separate organization, again, housed somewhere else with a separate board and separate staff.
Well, now, okay, I'd like to ask Dr. McLaughlin, on page 10, the bill uses terms such as, quote, excessive compliance costs, and also, quote, excessively burdensome. What exactly do those terms mean, sir?
I think that's a great question. I agree with your statement that some terms could be interpreted with subjectivity. And I actually think that on page 11 of the bill, the statement that the Commission shall establish a methodology for conducting its review hopefully goes to some length to addressing potential problems with subjectivity. So it is my hope, and in fact, I have a study that I just released this morning where I recommend methods for addressing the problem of regulatory accumulation. And one of the points that I make is an objective method of assessment is key. So I share your concerns, and I hope that can be dealt with.
And tell me now, on page 13, the bill requires the commission to review a rule that is identified by the public. So does that mean that if the Mercatus Center identifies 1,000 rules that it believes should be reviewed, then the commission would be required to examine each and every one of those rules?
Well, I think that the provision for allowing the public or any entity to propose a rule is designed to make sure there's equal treatment of all. Whether one entity attempts to dominate that is perhaps something to be concerned with. It's similar to the current notice and comment process that's implemented by the Administrative Procedure Act. So if there's a problem with this, there's also a problem with that, in that any entity can dominate the submission process.
Thank you, sir, and my time has expired.
Thank you. At this time, I recognize the gentleman from Missouri, Mr. Smith.
Thank you, Mr. Chairman. Mr. Professor Levin, in the closing part of your statement, I just want to correct. I think you made the statement, federal agencies are reliant on Congress in some ways. Is that correct?
I'm not sure exactly what you're referring to, sir.
Just in your last few sentences in your comments when you were given oral testimony, you made the comment, federal agencies are reliant on Congress in some ways.
I said that during my response to the chairman.
Okay, in your oral conversation.
Yes, sir.
And that brings a very important point to me that I want to make sure is on the record for this committee. Federal agencies are creatures of Congress. They didn't just exist. Agencies are created by Congress, and Congress can pass whatever laws it sees fit to cabin the authority of these agencies when they create laws. You know, federal agencies only exist because Congress has decided by law to delegate its legislative power to agencies. So that statement in saying that federal agencies are only reliant on some ways to Congress, where that agency was created because of Congress, is a huge problem, especially coming from a gentleman that teaches at a great university in my state. How do you respond to that?
Well, sure. What I said was that they are accountable, but I agree 100% with what you just said. They are creatures of Congress, and they are subject to congressional revision. Actually, not 100%. Congress can't pass a law that violates the Appointments Clause or other relevant constitutional restrictions. But broadly speaking, Congress can adjust their mandates. So on that, I think we essentially do agree.
Exactly. So that goes forward with the concern that you said that this current draft violates the Appointments Clause, which I disagree with. But I think we both could agree, and you even said in your testimony, that there could be areas where we could pass recommendations, or we could just, in my opinion, put it directly in the legislative branch, much like Senator King and Blunt's amendment bill over in the Senate. Wouldn't you agree with that?
That would solve the Appointments Clause problem, I believe. It would not, it would certainly not deal with all of the policy concerns. There's a potential non-delegation constitutional problem with with what is contemplated, but it does solve the Appointments Clause part.
But Congress has the power to say that we're going to create this commission to do this process, and in regards to appointing the individuals to serve on the commission, Congress can set the parameters. And this is just a thought off of the top of my head, but could Congress say that the president would need to appoint to this commission the 2 out of the 4 nominations that the Speaker and the Minority Leader present to him?
The constitutional criteria for appointment are not well defined in case law. I would think certainly the Justice Department would tell you that that is a violation of the President's prerogatives to appoint.
But doesn't the appointments clause also provide Congress has the power to decide in the appointment process of the president, of the courts, of the heads of departments, correct?
Not the clause. I assume the necessary and proper clause gives them some authority.
I'm talking about the constitutional clause of the appointments, the appointment clause
Right.
that you
The
brought
appointment
up.
clause itself says the President shall appoint.
But doesn't it say in regards to inferior officers that Congress can decide by law of those 3 different appointments of how they're appointed?
I don't think these are inferior officers. They have more power probably than any agency that exists today.
But if Congress would say that these commissioners are inferior officers,
And they would be mistaken.
but we
They are
could
not.
do that. So let's get to the policy process of this bill. Do you see that there's a need to reduce obsolete and duplicated regulations off the books?
Certainly.
What percent would you think would be a good target rate to, like 1%, maybe 5%, 10? What do you think would be a good target goal in reducing some of these regulations off the books?
I would not set a target because I think the process of weighing the costs against the benefits is an enormously complex matter, and I think it would be unhelpful to set a numerical figure.
So you would not want to say 1% of the regulations are probably outdated or obsolete?
I would not want to set a target figure because I think any such target would not be helpful in deciding which are the ones to eliminate.
So do you feel like 174,000 pages of regulations is too many or not enough?
I think there are many areas where many of them we don't need, and there are many more we do need. So how they net out, I'm not sure.
So no response. Thank you, Mr. Chairman.
Thank you. At this time, I recognize the gentleman from Michigan, a former chairman, Mr. Conyers.
Thank you, Chairman Bacchus, and I thank the witnesses. Let me ask my 2 friends, Mr. Batkins and Mr. McLaughlin.
I would be happy to ask one question.
If you were persuaded, and I'm not saying that you are already, that this provision could not pass constitutional muster, would that change your support for it? I'll start off with Mr. McLaughlin.
Thank you. First, I need to clarify that I am not formally endorsing this. I'm merely comparing the components that are in the bill to what I have laid out in my own research as elements that are necessary for successful reform. Secondly, I am a PhD economist. I'm not a constitutional lawyer, so I don't really have the wherewithal to weigh in on the constitutionality of the issue here. I apologize.
Well, that's okay. There are many members of Congress that can't either. But the problem is that if you were confronted by the legal opinions of constitutional scholars, would that affect your opinion?
My opinion is that there's a lot of merit to addressing the problem of regulatory accumulation from an economics perspective. And I would hope that issues like the constitutionality of any approach could be ironed out by legal scholars so that the issue can actually be dealt with. So my support would go towards dealing with the problem.
Mr. Batkins, the American Action Forum, how would you react to a finding of unconstitutionality on this draft measure that we are discussing here this afternoon?
Again, I just want to clarify that we did not, as a C3, we haven't sort of formally supported the bill, but just sort of the broad principles of retrospective review. As to the constitutionality, that's not something that I discussed in my testimony. I understand that there is the presumption of constitutionality and that going forward as this bill progresses, if there are serious defects, I'm confident that they'll probably be cured during the process.
Mm-hmm. Well, Professor Levin, would you care to make any comment about this issue, which a number of us, including yourself, have raised already?
About the constitutional issue? Well, I'll just elaborate a little bit on this distinction that Representative Smith made between principal and inferior officers, which I did not address in my first remarks. But beyond the fact that any officer who exercises significant authority must be appointed under the Appointments Clause, some may only be appointed by the President with senatorial confirmation. To be an inferior officer, you would need a superior. Well, this commission is not supervised by anyone. So in my view, they would be principal officers. You would need presidential appointment and senatorial confirmation.
Thank you so much. On page 10, Professor, you find the terms excessive compliance costs and excessively burdensome. And I wanted to review those with you, and it seems like there's so much subjectivity involved that it's kind of hard to for us to get it together.
Correct, they're entirely subjective, or at least undefined.
You know, exactly. And last but not least, on page 13, the bill requires the commission to review a rule that is, quote, identified by the public, unquote. So if Mercatus Center identifies 1,000 rules that it believes should be reviewed, would the commission be required to examine each of these rules?
Since I had only 3 days to examine the bill, I'm not sure about the specific point of what the scope would be. I generally agree with Mr. McLaughlin that a commission like this probably should look at submissions from the public. My problem is not that they're willing to listen, that they receive things from other people, but that I don't trust the conclusions they would reach.
Thank you so much, all of you. And I yield back the balance of my time, Chairman Bacchus.
Thank you, Chairman. This time I recognize Mr. Doug Collins, gentleman from Georgia.
Thank you, Mr. Chairman. I appreciate it. And I think this is definitely an opportunity to discuss the issues of transparency, the issues that we're dealing with here. And I think to include that further, I'm going to yield the balance of my time to the gentleman from Missouri, Mr. Smith.
Thank you, Representative. Mr. McLaughlin, we were talking about the independent, having an independent commission. Right now, how the process is that through executive orders, agencies, monitor their own policy of ineffective or duplicated regulations, correct?
Yes, sir. There have been a series of executive orders dating back decades that have exhorted agencies to review their own regulations. It's my opinion through research that none of them has had a substantive impact.
So where I come from in Missouri, we would call that the fox guarding the hen house. And that's why we need an independent commission that is going to do some serious work in finding, these regulations and to see if they're doing what they're supposed to be doing. What would you think would be a good target rate in what % of maybe regulations that are out there that this commission could find that are duplicated or obsolete? Would you say 5%, 1%, 25%? I'd like to have your judgment.
Unfortunately, I'm not going to be able to give you a number. And I think part of the reason is we don't know. As you've said a few times, there's over 174,000 pages in the CFR. That would take something like 2 years of someone's life to read. So to get to the point where we know what percentage to get rid of will first require a careful assessment of what we have on the books in the first place. I think that the assessment that's done by agencies, even if it were to be objective, could probably not deal with the number of rules that they've created over the decades anyway.
Mr. Botkins, would you want to give a target percentage of how many you think that may be out there that need to be amended or repealed?
I don't know that I could necessarily quantify it, but I can say that there is probably a lot of low-hanging fruit. Just from the reviews that I've seen from the administration, there's a lot of, it's 2014, there's a lot of sort of electronic reporting, updating that we can do aside from sort of the paper filings. I know that EPA has proposals for its National Pollution Discharge Elimination System and Hazardous Waste Management System that is moving towards electronic filing that, according to EPA, could save roughly $200 million annually. So I think there is probably some low-hanging fruit in the CFR, and a lot of that might just be, getting technology to 2014.
Would you want to take a guess and a percentage?
Like I said, I don't know that I could necessarily quantify it. I would say that
I'm not going to, hold you to it, but
yeah.
Say 15%, 20.
I mean, I would say that it's not necessarily the case, but the older provision, more or less, might be more ripe for review and amendment. But again, we've added a lot to the books just in the last few years. So, but again, I don't know if that I could quantify it.
All right, Professor Levin, have you read S1309, Senator King's and Senator Blunt's review commission? Because you mentioned it in your testimony.
Yes, S1390, I believe it is.
In 1309. And do you think that passes constitutional muster in the appointment of their commission?
As I recall, and again, I did not focus on that bill because it's not the one we are considering today, but roughly speaking, if the commission merely makes recommendations to Congress for Congress to act on, that is in general constitutional.
And if a commission is solely rested within the legislative branch, would it be constitutional?
If it's solely a legislative agency, it cannot exercise executive power, right?
Exactly. If the commission was just doing the work that was delegated to it by Congress, but it's set within the legislative branch, just like another committee in Congress.
It depends what the assignment is. The Supreme Court struck down the Graham-Rudman Act, in which power was entrusted to the Comptroller General because his actions were going to be legally binding, and you can't ask the Comptroller General to do that.
Thank you, Mr. Chairman.
Now yield back, Mr. Chairman.
All right, the gentleman from New York is recognized for 5 minutes.
Thank you, Mr. Chairman. Dr. McLaughlin, would you say that this bill is designed to address an urgent problem that confronts this country?
I think it is a significant problem. Regulatory accumulation, as I noted in my testimony, has been found to slow economic growth substantially, and that harms everyone.
Okay, so it's urgent because excessive regulation exists. Is that correct, in your view?
In my view, the regulatory process we have in America results in consistent accumulation over decades. There's no process for getting rid of obsolete, duplicative, outdated, or ineffective regulations, at least no streamlined process. And I guess one way to put this is an opportunity for us to improve our economy in the state of at the rate at which the economy.
Well, what's the adverse impact of the outdated, cumulative, excessive regulation that you speak to that you've characterized as a significant problem? What's the impact on the economy?
Primarily, it reduces innovation and entrepreneurship. People who would have undertaken some sort of entrepreneurial endeavor, maybe it could be, for example, Logan City, Utah was going to did install micro hydropower systems in order to create some clean energy for local residents. But they ran into a lot of regulations that were duplicative and not applicable to this particular scenario, and as a result, the cost of this environmentally friendly endeavor doubled.
Okay, this is the world's most significant economy. I get that you're pointing to a situation in Logan City, Utah, and I'm sure that's a wonderful place, but I'm asking about the significant nature of the problem that you've indicated, and for you to be able to point to evidence that exists as it relates to the impact of the economy. What evidence do you have? In a macroeconomic way.
Yes, sir. My testimony cites several studies that have been published in peer-reviewed academic journals, one of which is the one I cited in my testimony. However, others have been produced by scholars at the World Bank, at the OECD. The evidence is wide-ranging that a regulatory system that does not address obsolete and duplicative or ineffective regulations.
But give me an example of an ineffective regulation in the food safety area, for instance.
An ineffective regulation would be one that does not achieve its outcomes, does not have an effect.
I'm asking for an example.
I'm sorry?
Can you give me an example?
Of a regulation in food safety. I'm not an expert in food safety.
Okay. Give me an example of a regulation that fits that description of being outdated, ineffective, non-constructive in the occupational safety area.
Well, there is a regulation that I'm familiar with that is in the safety area. NHTSA, for example, requires headlights to be designed in a certain way, high beam and low beam. And the reason is you don't want the high beam to blind an oncoming driver. That regulation is, in my opinion, outdated because now adaptive headlight systems have been created, sold in Europe, sold in Asia, but not in America because this regulation prohibits them. This adaptive system would allow the high beam to be dimmed for the oncoming driver.
And your position is that, I'm sorry to cut you off, but my time is limited. Your position is that we need a presidentially sanctioned, legislatively authorized commission to deal with an outdated high beam regulation. That's essentially what you're here to testify to today?
The regulation is still impeding progress in our economy, and I'm sure that's only one of many examples that could be found were we to be able to go through all 174,000 pages.
Okay, can you give me an example in the consumer safety area of an outdated regulation that's having a devastating impact on our economy that requires us to move forward with some degree of urgency and connected with this legislation?
Sir, I think your line of questioning is actually underscoring the point that we do need to do a thorough assessment of all these regulations. There's no way I can sit here and come up with example after example after example because I have not spent my time reading all 174,000 pages of regulations. However, we have a good suspicion, I think, on both sides of the aisle for all parties involved that there are some there that could be gotten rid of and could offer chances for us.
Right, but sir, we're here to address problems that confront the American people, not enact legislation in search of a problem that heretofore, for me at least, has been ill-defined. One last question. So you took the position that you're not familiar with the fact that the Koch brothers have provided funding assistance to the center that you work for? Is that your position on the record?
We have a firewall separating research from fundraising. I'm not familiar with the details of fundraising. That's my position.
Thank you.
Thank you. Professor, there have been 3 executive orders by this president to review regulations, to look for outdated regulations, duplicative regulations, those that have more of a detriment than, or a cost than a benefit. Do you agree with an effort to systematically go through all the regulations and do a regulatory reform effort?
Mr. Chairman, I testified on this point in 2012, and I think there are diminishing returns to looking repeatedly at every regulation.
Do you have some? Oh. And I apologize. Rhode Island.
Yes, Mr. Chairman, thank you.
Yeah.
And I thank the witnesses.
Mr. Celestine, is
Thank
that
you.
how you pronounce it?
Cicilline.
Cicilline, yes.
I will concede for the purpose of this hearing that there are some regulations which are duplicative and unnecessary and obsolete, and we ought to eliminate them. That's, I think each of us could find one. But the notion of creating a new bureaucracy of unelected bureaucrats with no particular experience or expertise to make critical, often life-saving determinations about issues ranging from safe chemical levels to energy standards to healthcare is a frightening prospect, and I think something that I would resist with tremendous resolve. But I want to just try to understand how it would work even if you had your way. And the legislation says that in this cut-go, that the cost of any new rule to the United States economy has to be offset by a repeal. So I want to understand how we would calculate the cost of a new rule. So suppose you had a rule, and this is for you, Dr. McLaughlin, that said you have to have a level of this particular toxin below a certain amount because it proved to be very deadly to children. It's in children's food. And it would add a dime to the cost of food for children. But it would save countless lives. At high levels, it would cause infant death. It presumably would save thousands of lives. If you calculate the costs of the new rule to the U.S. economy, do you take into account not just the 10 cents, but there's no requirement that you net out the children whose lives would be saved, the children who would be healthier because they're not ingesting the toxin? Is there anything in this legislation that would net out what the value of regulation is? And if not, how do you possibly implement it?
It's my understanding that the analysis of costs for the cut-go portion of the bill for any new rules proposed would actually be performed by the agencies proposing those under their methods that they use right now. They perform regulatory impact assessment following OMB Circular A4.
But, Dr. McLaughlin, the statute that we're being asked to consider says the annual cost of the new rule to the United States economy. There's no assurance that there's actually even an assessment done about what the net benefit of any regulation is, right? And, of course, that's consistent with what you said in your opening comment where you said, currently, regulations by design restrict choices. Well, I guess that's true. It restricts the choice of a parent to have their child eat food which is poisoned, but it doesn't just restrict choices, it also is about keeping people safe, for example. Would you agree? Regulations don't just restrict choices, they also keep people safe.
Regulations have both costs and benefits, absolutely.
Okay, benefits are safety, health, right?
Regulations can...
And you agree we should keep those things, we should take those into account before we make a determination as to whether or not to repeal a regulation, correct?
I think that benefits should be weighed against costs.
And in fact, you said in a letter to the editor to The Hill, and I quote, you wrote, "It is unlikely that anyone knows what the actual net benefits of regulation are, although I maintain hope that further research can produce some reliable estimates." Those are your words.
Those are.
Okay. And so this bill would then allow individuals who have no expertise in a subject matter area to make a determination as to whether or not a regulation should be repealed based on the offset that comes solely from the cost to the U.S. economy without any consideration of the benefits.
I don't think that's a completely correct characterization. I don't know that it would be consisting of people without expertise in the area. I actually tend to think that we should make sure they have expertise in the areas being reviewed.
Well, don't we have another mechanism available to us both through the APA and through statutory directives obligating people who actually have responsibility and expertise in this area to do assessments and allowing individuals to petition for the repeal or review? Doesn't there already exist an infrastructure to do exactly what you're advocating for?
The problem with that infrastructure, sir, is that expertise does not necessarily equate to objectivity. So under current processes, the agencies review their own regulations, but it's not guaranteed that you'll get objective analysis. Agencies are stakeholders in this process.
But if, in fact, an agency refuses to repeal a regulatory provision that ought to be repealed, that matter can then be taken up by the Congress of the United States through legislative action.
Something that I think is very rare.
But there are mechanisms that currently exist to address the very problem that this legislation intends to address.
And in the study that I released today and that is on the record, submitted to the record, if not already, I'll make sure it is, I've addressed these efforts, and it's my conclusion that none of the efforts, none of the methods that we have right now for retrospective review are making much difference.
Thank you. I thank you, Mr. Chairman, and you back.
Thank you. There is a vote on the floor. So at this time, we're going to wrap up, unless, you know, Senator Joseph McCarthy's dead, but the ranking member may want to actually, you went into the Koch brothers, you may actually want to talk to Professor Levin. He's actually in the Anheuser-Busch Hall. You might actually want to see if there's some tie-in with the beer industry, which I know doesn't exist. I'm saying that in a joke.
I concede that I work in Anheuser-Busch Hall, Mr. Chairman.
Well,
We want to explore your beer preferences or whether your work is influenced by that being in the Anheuser-Busch Hall. So
I try to give sober assessments, sir.
thank you.
Mr. Chairman, if I might, I'd like to offer, with unanimous consent, these two letters, one from the National Resources Defense Council and the other from the Coalition for Sensible Safeguards, both of which oppose the Scrub Act. I'd like to submit those for the record.
For the record, and the National Resources Defense Council, we could have predicted that, couldn't we?
Well,
So,
it's just as we could predict that Karl Rove and the Koch brothers are in favor of less rules.
yeah, or Anheuser-Busch folks. I don't know. There's somewhere, there's got to be in there somewhere. No, I appreciate it. Without objection.
Thank you.
This hearing is adjourned. But Professor Levin, I would like to explore with you whether there's some bipartisan way to, you talked about to look at these regulations.
Okay.
So, and
Well, I take it you're wrapping up, but I'd be happy to work with the committee over time in looking at alternative ways of dealing with retrospective review.
thank you. This concludes today's hearing. Thanks to all our witnesses for attending. Without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. This hearing is adjourned.
Thank you, Mr. Chairman.